Hello there. In today's session of Learning the Law, I would like to examine the topic of the emerging multipolar world in international law, where we are concerned about the accountability and the future of global order in the world. Of course, international organizations and world leaders have acknowledged that we are living through a structural transformation of the international system. The historical background is that the post-Cold War period, which was usually referred to as a unipolar moment, dominated mainly by the United States when emerging from this Cold War era, had been a deeply bipolar world, balancing interests of the United States and Western Europe, who were opposing or sometimes in agreement with each other over economic and political policies. In today's world, power is diffusing across multiple centers: geopolitical, economic, technological, military, and in other ways. And so some of the major actors shaping this new multipolar world are China, India, Russia, Brazil, the European Union as an entity, the African Union as a source of many resources, and other coalitions beyond BRICS. And for legal scholars, this shift or this evolution in terms of power now begs the question: can international law remain authoritative and coherent in a multipolar system? The shift from unipolarity. The question for legal scholars in this major shift is: can international law remain authoritative and coherent in a multipolar world? Because multipolarity is not merely geographical, it is juridical and economic. And as power diffuses among actors such as China, India, Brazil, the African Union, and others, which I had earlier mentioned, we also need to ask ourselves: can international law remain universal in this politically plural world? To be able to answer this question, we need to understand multipolarity in its legal sense, because it is not merely a political phenomenon, it's actually a structural distribution of authority which affects norm creation, treaty negotiations, enforcement of international responsibility, and institutional legitimacy. And from a doctrinal perspective, multipolarity will test some of the universality of our international norms, also the durability of collective security mechanisms, and the neutrality of some of the adjudicatory institutions and tribunals around the world. What are the risks in the international order in this shift? Firstly, where power politics are changing, some of the shifts are selective enforcement, which would undermine consistent application of international law. And also, as norms begin to change, in discussing the risks to the international legal order as it presently stands, legal scholars and others have seen that several tensions are emerging. Firstly, institutional paralysis. We are all aware that the veto structure within the UN Security Council prevents decisive actions when it is critically required. Secondly, that power politics can often undermine the application of international law the way it should be. And that where norms begin to fragment, we risk having divergent interpretations or selective interpretations of fundamental concepts like sovereignty, state intervention, human rights, and other very basic norms which have been under customary international law. There's also the fact that accountability becomes eroded, and the geopolitical alignments may in fact shield certain leaders from prosecution before the ICC, which should not be the case. And so how can this new multipolar world be enabled, as it were? Firstly, the international institutions, which seem to be losing power, in particular, the United Nations, need to be re-examined and redefined. Long has been the cry for reforms of the United Nations. Article 109 allows for amendment of the United Nations Charter, in particular the Security Council and other aspects of the United Nations Charter. Article 109 allows for the reforms of the United Nations, and the key element or key body of the UN which requires reforms is obviously the UN Security Council, where the veto power has rendered this institution ineffective. Also, the absence of key stakeholders such as the African Union and its members, ASEAN and its members, and the GCC and its members, it really renders this component of the UN very powerless. And so reforms of the UN are necessary if this body is to be relevant in the future multipolar dispensation. Secondly, to ensure criminal accountability, the ICC must avoid this perception which currently exists of selective justice, and also secure some state cooperation which is much broader than the current levels, and to strengthen complementarity between itself and member states. In order to enable this new multipolar world, the African Union and other bodies are looking forward to operationalizing mechanisms against unconstitutional changes of government. So regional enforcement becomes critical in strengthening the new order of things in the world, where constitutions should not be violated, and that where there are grave breaches of international law, then there ought to be consequences which are felt. So how can this... Now, in order to enable this new system, there are a number of points or structures which must be looked into, re-examined, and restructured. Firstly, there must be a creation of a new accountability system. Multipolarity definitely demands institutional innovation, and therefore there must be treaty-based frameworks which would trigger automatic sanction mechanisms so that punitive systems based on global accountability norms are enforced by sanctions, sentencing, and other mechanisms for perpetrators of the violations of international law. Further, it is very important to introduce anti-corruption mechanisms globally. In other words, to strengthen what currently exists and to address transnational financial flows which are illicit and corruption levels globally. Digital governance is also an important factor in this new multipolar world, where current norms which are evolving, particularly to do with artificial intelligence, cyber crimes, and disinformation, as well as other artificial intelligence and digital regimes, are re-examined, and the crime system, penal code is globalized so that norms governing crimes and violations can be regulated by law. Further, an important aspect of strengthening international norms is to build on the articles of state responsibility in order to ensure that reparations for injured states are made by the wrongful states, and that guarantees of non-repetition are supported by enforcement. Also, collective countermeasures against states, violating states are consistent across the board and not selective, and enforced with legality. A very concerning point are that some of the norms in a multipolar world, which must remain non-negotiable, are inclusive of norms and definitions such as sovereignty, which include territorial integrity, political independence. This is foundational to international law. And so sovereignty going forward must be strengthened. It must be recognized. This is non-negotiable. Non-intervention. So the principle of sovereignty coexists, of course, with non-intervention. And this was affirmed in several cases of the International Court of Justice, that there should not be interference in the internal affairs of states, but other mechanisms and other measures can be used. Secondly, sovereign equality. This concept, this idea affirmed in Article 2, Sub-Article 1 of the UN Charter, that states are legally equal. It's a real provision of the Charter, and it must be recognized and enforced. Thirdly, a fundamental principle of international law is the requirement. Thirdly, an important principle of international law is the peaceful settlement of disputes, as stipulated under Article 33 of the UN Charter. Article 2, Sub-Article 3 of the UN Charter obliges state parties to resolve their disputes by peaceful means. This was reinforced by several cases of the International Court of Justice, including the North Sea Continental Shelf cases of 1969, where the ICJ emphasized good faith in negotiation, equity in maritime delimitation, and other factors where peace is a requirement for the regulation and the resolution of international disputes. So peaceful settlement as well as state responsibility, this is a non-negotiable concept. The idea that a wrongful state must make good or make amends to the injured state, and that wrongful acts trigger obligations of cessation and reparation. This, of course, was reinforced by the case of the Chorzów factory between Germany and Poland in the predecessor of the ICJ, the Permanent Court of International Justice. In saying all this, what are we saying? We're saying that in a multipolar world, legal scholars do understand that in order to maintain peace and security, in order to observe the aspirations of peace and also equality of nations, equality of voices, we must maintain order as it were. The order, the norms and values of international law must be maintained. Sovereignty, non-interference, state responsibility are fundamental principles of international law. And if we consider the Latin maxim, pax per justitiam et aequitum inter gentes, meaning peace through justice and equality among nations, this really is what the early philosophers of international law spoke of. The other, besides Alberico Gentili, Hugo Grotius, and other speakers, all early philosophers had emphasized that the world must be a place of peace, of justice, and of equality of states. this fundamental principle does not change with modernity. In fact, in a multipolar world, the legal order must achieve not dominance but justice, and not silencing others but encouraging equal participation on the global scene. So as I conclude, I would like to say to my students and to legal scholars, let us critically examine some of these power asymmetries where we see that things are not aligning with universal legal norms, and let us promote coherence in legal doctrines and advocate for reforms, principled reforms, so that the legitimacy of international law will not only depend on institutions, but on intellectual integrity and consistency. For today, this was my message: peace and justice for all, despite the differences of state